Hello and welcome. My name is Sharon Burke. I was born in Newry when my mother was in Marion Vale, the Good Shepherd home there. I was subsequently transferred to Dublin to an institution for babies called Temple Hill, from where I was adopted 3 months later. I now live in the US, from where I'm speaking today. After a long campaign for justice by survivors from Mother and Baby and Magdalen Laundry institutions in Northern Ireland, we now have the opportunity to co-design an inquiry into the human rights violations that mothers and children experienced. Some of these were documented in the recently published study that was commissioned by the government and completed by a team from Queen's University and Ulster University. Others merit further investigation and have yet to be fully uncovered. A 6-month government-established process of co-designing an inquiry is now getting underway. This is our chance as victims and survivors from these institutions to determine the design, powers, duration, and terms of reference of the investigation. Amnesty International and Ulster University have organised this series of online events with survivors and other experts from here and overseas to help us navigate this process and the decisions that lie ahead. This inquiry is our chance to set the record straight and to receive justice, to fully investigate what happened and why. Today, Northern Ireland no longer discriminates against women as it did in the 20th century. It honours and treasures all mothers and their children equally. But it's important to understand the road we've taken to reach this better place and what we need to do now to complete the journey, not only for ourselves and for our family members who are no longer here, and for those who did not survive those cruel times, but also for the benefit of all in Northern Ireland, because only by acknowledging the harms of the past can we understand how easily anyone's rights can be violated. So this is our chance to tell the truth, and in so doing to strengthen the human rights protections of all who live in Northern Ireland, so that nothing like this can ever happen again. So now, let me introduce today's great panel. We're joined by Professor Brandon Hamburg of Ulster University, Gemma McKeown from Committee on the Administration of Justice, and John McCourt of Survivors Northwest. Each will speak for about 10 minutes, and then we'll take a few minutes to draw the strands of the conversation together. First up is Professor Brandon Hamburg. Brandon is the John Hume and Thomas P. O'Neill Chair in Peace at Ulster University. He's based at the International Conflict Research Institute and is a member of the Transitional Justice Institute. Brandon has written extensively on the South African Truth and Reconciliation Commission and has worked with Professor Patricia Lundy on victim-centred approaches to historical institutional abuse. Today, Brandon will share his thoughts on the pros and cons of truth commissions, which are victim-centred approaches to investigating past abuses, and about survivor participation in historical abuse investigations. Brandon, you're very welcome.
Thank you. Thank you very much. And thank you for inviting me to be here today to share some of my thoughts. By way of background, I'm a clinical psychologist and I trained in South Africa as a psychologist, and a lot of my work there focused on working with survivors of the apartheid past, of the human rights violations that took place in South Africa, and accompanying and working with a range of different survivors as they went through the Truth and Reconciliation Commission process in South Africa. From there, I've gone on to work in a range of other countries, looking at similar processes and particularly researching how different experiences of victims through those what we'd call transitional justice mechanisms and how that has been and how they've experienced that. And I've worked, for example, in helping design statement-taking processes in the Liberian Truth Commission, amongst other contexts. Although I have worked with Patricia Lundy, and some of the thoughts I'm going to share are those of hers as well, and ones we've workshopped together today. I wouldn't necessarily see myself as a complete expert on historical institutional abuse, but rather my focus is on wider political conflicts. But hopefully what we've learned through those processes over many, many years now and decades might be helpful to the discussion that we're going to have today. And of course, historical inquiries are different to transitional justice processes, but they also share some overlap in terms of their focus on victims, in terms of their focus on human rights violations, often on long periods of time. And so hopefully there'll be some sharing that we can take from that. Let me begin by just outlining what I'm going to do is just talk about 4 key lessons that we've learned from transitional justice over the last couple of decades, and then I'm going to just make 5 recommendations. And the first lesson is that there has been a growing focus on trying to make transitional justice processes more victim-centered. And when I'm saying transitional justice processes, that's quite wide. It could be truth commissions, it could be inquiries, it could be historical commissions, it could be trials, a range of different processes that could embody. So there's been a growing focus on making victims more central to these processes. There are a number of statutes and frameworks that have been developed at levels like the United Nations talking about the importance of victim participation. And in that level, there's a lot to learn in terms of that sort of normative setting of specific standards around victim participation. And what we know is that when victims and processes are victim-centered, they are much more credible, and they also lead to trust in institutions. However, the first lesson that we've learned over the years is that actually the rhetoric has not often matched the practice. And so if there's one lesson we want to take is, let's not talk about victims and participation unless we're really meaning that participation. And that's before processes, during processes, and after processes. And sometimes transitional justice has fallen down on that grounds. The second big area of learning has really been around the issues of testimony and healing, and what does it mean for people to speak out and talk about their violations, and does that make a difference? And the research certainly shows that for some victims, that's a beneficial process. It can help to break the silences in society. It can sensitize people to what's going on. So if we look at South Africa, for example, there were more people watching the summary program of the Truth Commission at the end of every week than the news. And now they might have had different opinions about what they were hearing, but those stories were being put into the public. However, there are also limits with that. What the research shows, and my own research, is that for many of those giving testimony, sometimes the benefits are quite short-lived. They feel a sense of relief. They feel that people have heard them. But down the line, they start to question, well, what change did that really make? And what that means is that these processes are interrelated. So questions of justice, questions of truth, questions of what reparations or compensation follow are also linked into the value that people will give to the testimony that they put forward. So, for example, if there's a compensation process but there's no justice, then for many victims or survivors, they're going to feel like that's blood money, that they're taking money to keep quiet rather than for justice to be delivered. So there has to be a level of internal integrity between a range of different processes like acknowledgement, truth, justice, and all of that contributes to the healing. And what we know from wider processes around truth commissions is when that's missing, the testimony only will have some limited value. And so you have to look at it holistically. The third area, and I've touched on it already, is really the value of participation. And what we know is that participation increases a whole range of benefits, not only for the person actually giving the testimony, but it creates a wider social trust in the institutions that have tried to address these type of issues. But as I said, what we've also seen is that often that participation is quite limited. So it's seen as, when you give your testimony, that equals participation, rather than actually a long-term systematic engagement. The fourth lesson we've learned is really the value of also localizing experiences. And although this might not relate directly to the Northern Ireland context, what you're seeing in many countries now is a recognition that you need a formal process, say a truth commission or a justice process, but this needs to be complemented with local processes, which, say in Uganda or in Sierra Leone, might be local traditional healing strategies where communities are engaged in a wider discussion. And I think that has relevance to Northern Ireland, where these processes should not be something which is just about a certain constituency who have been directly affected, but about a wider society. And how do you engage those wider communities? How do you speak about it in schools? How do you speak about it in churches? How do you speak about it in universities, for example? And the research shows that when you widen out those processes, they tend to have more value. So those are really 4 key lessons that we have learned. If I was to be pushed and said, well, what then does that lead to, and what type of recommendations would you make? Well, the first of those is that obviously it's important we don't repeat a lot of the mistakes we've seen in truth commissions and transitional justice, where we talk a good talk about the role of victims and their participation, and that these processes are victim-centered, but in reality, the victim's actual role in the process is quite limited, or the process becomes very adversarial, there's not a recognition that actually the wider issues of justice and truth don't key into how they might look at the process. And that links to the first recommendation, which perhaps it sounds very simple, but in practice is very difficult, is that victims' needs need to really be the engine of how we address past human rights violations. And that word needs is really important, because the needs are often much wider than just the need to give testimony or to be heard. The needs could be a consequence of the violation, could be ongoing deprivation or systematic types of poverty. And so you need to think of those needs in a wide way. And then you need to also think of them in a narrow way. And in the narrow way, that might mean there has to be adequate counseling, there has to be briefings and debriefings before victims engage with processes. Questioning needs to be victim sensitive. It shouldn't be a process that's very adversarial. There should be avoiding of things like delays and administration errors. These are really important. These sort of basic administrative treatment is really important, because for many victims, they've often felt, from my research, that different state institutions have been, and other institutions have been, those that have victimized them. And every time an institution then fails to follow up on something, or you phone and they can't find the paperwork about your case, it feels like that victimization is happening again. And so, you also need to get those micro processes right. And there needs to be support, for example, on literacy or understanding the forms that people are sent. So some of those basic things are as important as getting some of the wider issues right. The second recommendation would be that, the value that transitional justice thinking, I think, brings to these type of processes is it widens it out. It says, it's not just about the violations, but it's about transforming institutions. It might be about opening archives. It might be about memorialization, compensation, apologies, and that these processes are all interrelated. And so the second recommendation would be to also think beyond just these types of inquiries. How are we going to put this into an educational curriculum? How are we going to learn from the mistakes of the past beyond some form of rhetoric? What does it mean for issues like apologies or memorialization? The third recommendation would be we really need to make sure we don't, what one might say, instrumentalize victims or survivors, that these don't become tick box exercises. Oh, we have to consult survivors. We've consulted them. Now we'll go ahead with this very legal and adversarial process. It needs to be a genuine form of engagement and participation. And that's a really difficult thing to achieve, but is absolutely vital if these processes are to be properly survivor or victim centric. The fourth recommendation would be we have to support local initiatives. And the research shows, and Patricia Lundy's research showed this as well, that those who receive additional support, say through NGOs, civil society groups, advocacy groups, tend to look at the outcomes of these type of processes more favorably. They feel they have more control over them. They have more level of influence. So when we're saying support victims and survivors, it's not only about supporting people through the journey, and I spoke about that in terms of administrative and other treatment and counseling and other types of support. It's also actually about supporting the wider environment, that there are actually groups who can support individuals, that are providing advocacy or providing a home outside of the formal process. And then the fifth and the final recommendation would be, again, one of the values, I think, of a transitional justice way of thinking about the past, rather than just an inquiry-centric way of thinking about the past, is that what transitional justice tries to do is create a wider narrative about the systemic nature of certain types of violations. And so if you think of the South African Truth Commission, it looked at the causes, the nature, and the extent of the conflict. So the emphasis is not just on how many people were abused, how did this happen, what was the nature of it, but also why did it happen? what were the wider societal dynamics around that? What was the role of different institutions that were meant to protect individuals? How did this happen in a wider societal way? And how do we tell that narrative and tell that story so that we can learn for the next generation in a much more holistic way? So thank you.
Thank you very much, Brandon. That was really informative. And now I'd like to welcome our next speaker, Gemma McKeown. Gemma is a solicitor working for the Committee on the Administration of Justice, a leading human rights group in Northern Ireland. She has extensive experience of inquiries and investigations into human rights violations, particularly related to the Northern Ireland conflict. Today, Gemma will answer the question, what does a human rights compliant public inquiry look like?
Okay, thank you. Thank you, Sharon. So I'm going to outline what a human rights compliant inquiry looks like. And at the outset, it's probably quite useful to set out what the aims or functions of an inquiry are, a public inquiry. And there are generally agreed three areas of focus, i.e. what happened, why did it happen and who's responsible, and what can we learn to prevent it happening again. And over the years, there's been a variation of reasons as to why people have called for public inquiries. It's ranged from wanting to establish the facts, address public concerns, for voices of victims and survivors to be heard, to provide an historical record, accountability, acceptance of responsibility, truth, justice, others want prosecutions, and remedies and reparations, acknowledgement, lessons to learn to prevent repetition of the same violations, and changes to policy and practice. And not all of those desires are ultimately necessarily achieved through a public inquiry, but some can be. I'm going to focus on the experience that CAJ has had from observing a number of public inquiries that took place in Northern Ireland as a result of the political agreements following the peace settlement. And they are the Rosemary Nelson inquiry, the Billy Wright inquiry, and the Robert Hamilton inquiry. Two of those inquiries were under the Inquiries Act 2005, and it states that an inquiry under that act cannot make civil or findings of civil or criminal liability. Now, that doesn't prevent an inquiry deciding or identifying misconduct, which potentially could lead to prosecution, but that isn't the primary objective of an inquiry. And any inquiry under that act has to be read in consideration with the rules that go with it. And for the purposes of our conversation about what an inquiry would look like for the treatment of those that were in the mother and baby homes and the Magdalen laundries, there are a number of relevant European Convention human rights protections that really are relevant. At the outset, the right to life, the right to be free from torture, inhumane or degrading treatment or punishment, the right to be free from slavery and forced labour, liberty, the right to respect for private and family life, which includes access to personal information, and the right to have an effective remedy where there's been a violation, and the right to enjoy these rights free from discrimination, which includes on the grounds of sex and social origin. And I'm going to focus in particular on what are called the investigative requirements, so where there's been an arguable breach of the right to life, to be free from torture, and the right to be free from forced labour or slavery. The authorities have an obligation under the European Convention to actually investigate it. And these investigations have to have certain requirements. Initially, it's essential that the inquiry is actually established by the state or the authorities of their own initiative. It shouldn't be initiated by those affected. It must be those who hold the investigation must be independent of those implicated. It must be effective, public, and the victim, which is the language the European Convention uses, the victim or next of kin must be involved to the extent necessary to safeguard their legitimate interests, and it must be prompt. I'm going to focus on the issue of independence. So any inquiry into human rights violations really must be independent, both practically and in perception. So, for example, it's paramount that the chair and the panel are independent of those implicated, and also that they have their own independent legal team. There are, however, some concerns in relation to the Inquiries Act 2005. It has the potential to undermine this independence For example, it allows a minister to halt an inquiry and to issue what's called restriction notices, which effectively means they can stop someone attending an inquiry or restrict disclosure or publication of documents. And also they can withhold information from an inquiry and withdraw funding. So there are potential issues of consideration that have the potential to interfere with the independence requirement. It's also important that a human rights compliant investigation is effective. And what that means is that it must be capable of leading to the identification and punishment of individuals. And this is an obligation of results, but not means. So the authorities must take all reasonable steps to collect evidence, and all investigations must be based on a thorough, objective and impartial analysis of all the relevant elements. Now, under the Inquiries Act, the inquiry would have certain particular powers that other inquiries don't necessarily have, which allows the inquiry to compel a witness or evidence under Section 21 of the Act. And if a witness fails to comply with that, they have the potential to risk 6 months in prison and up to £1,000 fine. And two of the inquiries, the Billy Wright and the Robert Hamill inquiry, converted to Inquiries Act inquiries to ensure that they had those stronger powers. And in fact, the Robert Hamill inquiry used the power on a number of occasions against an individual witness who failed to comply, and actually went as far as issuing High Court civil proceedings against her. It's also important that any human rights compliant investigation provides accountability. One factor that potentially could undermine this is the ability of an inquiry to provide undertakings to a witness. Now, the purpose of an undertaking is really to ensure that a witness is as honest as possible, and an undertaking would be something provided by the Attorney General or the Prosecution Service, which would state that any evidence that person gives wouldn't then be used against them in criminal proceedings. But that isn't to say that the evidence of another witness couldn't be used against that person. For example, in the Robert Hamill inquiry, there was an undertaking such as that, but the undertaking only went as far as their evidence, and if they provided false evidence to the inquiry, that would not be protected. In the inquiries that we monitored, anonymity was also granted on a number of occasions to state witnesses, and there is a question as to whether that potentially undermines the right to accountability and actually having access to the truth. It's also important that all investigations are prompt. Neither of the three inquiries that we monitored were prompt. They took a lengthy period of time before they were initiated. They followed lengthy consultations and campaigning by family members. And in fact, the Robert Hamill inquiry still hasn't actually published its report, as there is ongoing legal criminal proceedings still pending. Another element of a human rights investigation is that it must be subject to public scrutiny. And the Inquiries Act works on the presumption that an inquiry will be held in the public, and that they should be able to either public can attend, or in fact access the inquiry proceedings through broadcast media. However, they can limit this if there's a risk of harm or damage, or given the confidential nature of the evidence given, or if it would cause excess delay or additional costs. It's also important, and one of the central factors of a human rights compliant investigation is that it is victim led. And in all three inquiries, the next of kin were treated as core participants. And a core participant is someone who will be granted particular protections and status if you have a direct or significant role in the matter under the review of the inquiry, or if you may be subject to explicit or significant criticism. And it gives you extra powers and protections. For example, a core participant can receive disclosure, will have legal representation, they can suggest questions to the chair or the panel, they get access to the report in advance, and they have greater powers to question other witnesses that don't have the core participant status, and they have the right to make an opening and closing submission. So they really can have a central role in informing how the inquiry progresses. And just in conclusion, based on sort of our experience of looking at inquiries and forward looking obviously as to what kind of process will materialise for the victims and survivors of the mother and baby homes and Magdalene laundries, it's essential that any process must be embedded in human rights standards. And a human rights-based approach must inform that from the outset, from the nature of the terms of reference. Obviously, that's an ongoing process as we speak, but it's essential that from the outset, victims and survivors must be central to that conversation. It must be free from political interference, and it's important to ensure that all necessary steps are taken to avoid traumatization of survivors in the process. It's important that there's a very strong chair and legal team, hopefully and potentially with human rights expertise. They need to act promptly, and they should consider giving core participant status to survivors, and they should consider the use of expert witnesses, and to granting observer status to human rights groups and others who have been working on the matters under review. It's essential that they have effective powers of compellability for both witnesses and to get evidence and to get disclosure. They should exercise caution in the use of undertakings, and there should be a presumption that all hearings should be public, with the appropriate measures taken in place to protect survivors. And they should consider issuing interim reports if there's an urgent matter, and make strong recommendations, including on redress. And as well as the European Convention on Human Rights, there is a realm and raft of other international human rights standards that are relevant, such as the Convention on the Civil and Political Rights, the Convention on the Elimination of Discrimination Against Women, the Convention Against Torture, on the Rights of the Child, the Forced Labour Convention, and there's also a vast number of declarations and principles that need to inform any investigation going forward. And even 2 years ago, as we know, the Committee Against Torture made it very clear that there needs to be an impartial and effective investigation into the practices of the Magdalene nunneries and the mother and baby homes that leads to the identification of victims of ill treatment, and also, most importantly, to provide them with redress. So they're all relevant factors that really need to inform any decision-making process going forward. Thank you.
Thank you very much, Gemma. That was really helpful. It's a very complicated topic. I already have a couple of questions that I would like to ask you. But first we'll go to our final speaker, John McCourt. John is chairperson of Survivors Northwest, a group of victim survivors of historical institutional abuse in Northern Ireland. He campaigned successfully for the HIA inquiry, also known as the Hart Inquiry, and for its subsequent redress scheme. And he was himself a participant in that inquiry. John's going to talk to us about survivors' experiences of the Hart Inquiry and share with us some of the lessons learned from that experience. So welcome, John.
There were two things I set out to do. One was to get an inquiry, and the second was to get some kind of recompense for the damage that had been caused to people in these institutions. And by the time we get the legislation through in November 2019, that was actually happening. The inquiry had already taken place. So, it was a long road from 1994, 2009. And the Irish government announced an inquiry, which was the Lafoy inquiry, eventually became the Ryan inquiry. And again, I thought, here's the opportunity. And what I was actually told was, we're just a year after the Good Friday Agreement. You really don't want to go upsetting the apple cart by trying to get across. I wanted the Ryan inquiry to become an all-island inquiry. I wanted the same inquiry to be taking place in the north at the same time, because I was very aware, living in the border county, that people were being, in the 40s and the 50s and the 60s, people were being shipped back and forward as babies back and forward across the border. And a lot of them lost in the mechanism that was supposed to be caring for them. So, there were a few other dimensions in this that are very, very relevant to the hopefully upcoming inquiry with the mother and baby homes. Because again, children were moved across the border. They moved to Sligo, they moved to Galway, they moved to Donegal, or wherever it was. And it's just something I think that has been. If there was a flaw in the drafting of the terms of reference for the historical institutional abuse inquiry, I think it was actually seriously taken on board that cross-border dimension. But the inquiry is taking place. There is a recognition that people were taken across the border, and hopefully that's going to be something that's going to be more to the forefront with the mother and baby homes. there were things that we agreed on, that we should move forward, there were asks that we wanted in there. And we discussed them. We sat in a group at one point, had 30, 40 people in a room, and everybody sort of throwing in their contribution as to where we should go with this. When it came to financial compensation, when it came to the terms of reference of the inquiry, who should be included, who shouldn't be, all of that stuff. We sat, we discussed it, we came to a consensus, and we went forward with whatever it was that we had agreed. A lot of the decision making was group decision making. And, I had to take my lead from the group, because there's no point in me going out there on my own deciding I know what's best. Honestly, much as you may think, you know what's best, you really don't until people tell you. So again, it was like constantly going back, giving feedback to people from meetings that we attended, and, and getting their view on it. I found that it was a challenge in a way, because sometimes you're in a room, and maybe in a room on your own, and people have to trust you that what you're telling them actually happened. So I had notes of everything. I had civil servants who actually sent me down the talking points from a meeting, just to confirm that what I was saying to people was actually what happened. So if I come out of a meeting and I said, this is what was agreed, or this was not agreed, this is what was said, or this was what was promised, you can trust me that that's actually what happened in that room. I think there's a thing about, being upfront and honest with people, even stuff they don't want to hear. Sometimes they have to hear it, because they have to make their decisions based on the information that they're given. We couldn't get 40 people into a meeting with the head of the civil service. We couldn't get 20 people into a meeting with the Secretary of State. So they had to trust me and trust us to bring back exactly what happened in that meeting. The civil service, I found initially, were actually not initially, almost all the way through this, I found that the civil service was very, very cooperative. Yeah, they had their own, they had their sort of fort that they had to protect. They had their budget that they had to protect. They had, their way of doing things is something that I wasn't used to working with. But again, I found if you were clear with them, if you were clear on what you were writing to them and what you were saying to them, they could take it away, they could look at it, and they could see whether it could move or it couldn't. And I think a lot of the stuff, on a first ask, most of the stuff that I put in front of the head of the civil service or the team that had been put together by the executive office to look at the issue of historical institutional abuse, were able to take mostly what it was that was being put in front of them, discuss it among themselves, come back and argue over a point. But again, I think, don't be afraid of the ask was something that I learned. Don't limit yourself to, I can't ask for that. Ask for it, let them give you a rationale or a reason why it shouldn't be delivered, rather than assume that it won't be delivered. I think maybe if there was one thing, and I'm particularly interested in the terms of reference for this upcoming inquiry, if there's going to be an inquiry. Because in the case of the historical institutional abuse inquiry, and Amnesty are aware of this, and other people that we work with, and are aware of this, that the civil service went off, political representatives went off, and they came back with the terms of reference that for us it was a fait accompli. They had decided what were going to be in the terms of reference. We would like to have seen more in there. And in fact, they eventually had to change a part of the terms of reference to extend the time frame of the inquiry, from 1945, put it back to 1922, because there were people who were in institutions before 1945, even though the terms of reference had actually stated that they would be given consideration. We didn't want someone who'd been born before the time frame of the terms of reference. We didn't want them given consideration. We wanted their evidence and to be there as of right, rather than a consideration. So, part of it is, it's the points that you're prepared to fight on. It's what you're prepared to push. But at the bottom of this, irrespective of, what fighting or arguing was done in a room, the bottom line was that there was a constituency of victims and survivors out there, many of whom had never heard about this inquiry or what it was we were attempting to do, but others who were on board, that we had to represent and ensure were represented in that inquiry and in any legislation that would be drafted to move this forward. So I think, starting off knocking doors at 9 and 10 o'clock at night. I remember it was a winter going to Donegal, the snow on the ground, 10 o'clock at night, right? And the guy was very welcome and very, very nervous. He hadn't seen me since I left the children's home. But again, he understood what it was we were trying to do. This wasn't about embarrassing people through their experiences. It wasn't about highlighting people if they wished their anonymity to be maintained. That was fine. But what we needed was a body of evidence to convince the government and convince an inquiry that there was something in these institutions that needed to be investigated and that they needed to resolve and they needed to address. And eventually the inquiry itself, the process of the inquiry was difficult for a lot of people. Again, there were things in the process of the inquiry that I would like to ensure would not happen again. One of the things is timely disclosure. People giving evidence to an inquiry on their way into the room, actually being stopped on the way into the room and just being told something that completely flipped their memory of whatever it was they were just about to give evidence about. Somebody who, for example, and this may not be a real one, somebody who, for example, was under the impression that they were put into a children's home by the local priest or by the St. Vincent de Paul or by somebody else on their way in to give evidence, being told at the door, just as the door's opening, that actually your mother or your father put you in care. I mean, that's bound to knock somebody right back, So again, that whole thing around timely disclosure, I would have preferred, particularly in the inquiry, if there was something like that coming forward, that they would decide, we're not going to hear your evidence today. We have to tell you this, and we want you to work, to work your way around it. To get it clear in your head that maybe you're going in here with one impression, and here's something we've just got back from the Sisters of Nazareth. You'll find the institutions are have been very, very reticent about putting all of the evidence that they have on a particular person, all of the files on the table so they can be reviewed. So, to be aware of that, you may not get everything that you want from an institution. You may get something. And in a lot of cases, what you get are 2 lines or 3 lines. The day you went in, the day you made your confirmation, or some other, sort of memorable event while you were there, and the day that you left. And many, many people, rather than have what they believe would be a record of their time in an institution, end up getting 3, 4, 5 lines with their name on it, their date of birth on it, the day they went in, the day of a particular religious ceremony, whatever that may be, and the day they left, and that's it. So, counting on records, you're going to have to count on memory, you're going to have to count on your friends, you're going to have to count on your family, to ensure that what you can put together will actually become a body of evidence that will become your case against an institution. So, it's that sort of thing that, that I know was off-putting for a lot of people, particularly if you were there as an observer, and maybe your call to give evidence may have been a couple of days down the line, and you see what that sort of late presentation of facts does to somebody, and you also witness what goes on in the inquiry chamber and the event itself. It is a bit intimidating. I remember going up, getting a look at the situation in Banbridge, at the courthouse in Banbridge. I came down with a drawing to show people where the panel would sit, where the barristers for the institution would sit, and stuff like that, just so people had an idea of what they were walking under. Because you have to remember, most of the people that we're talking about would never have any experience of a courthouse setting. So this is a frightening thing for a lot of people. So, there are challenges in it. I think one of the things you find is, if we look at some of the pluses, there were rekindled relationships that had faded away 50 years ago when people came out of institutions, and they're meeting some of the people that they were in the institution with. They share the stories, and there are a lot of tears, but there were some fun as well, And I think, hang on to those things, because the horrible memories are always going to be there. I think the memories of the laugh and the joke, that people shared as children is something that helps overcome that. So, while the whole thing is a heavy, heavy process, I'm not saying it's not frightening. I'm not saying it's not intimidating, but it is something that is possible for people to get through. And to enable them to get through that, it's important that the right sort of support, service, and support network is there for them, among their friends, among their family, and that creates difficulties for a lot of people who would be coming forward to inquiry. Having to share the story maybe with their family for the first time. It's not easy. But I think it takes a lot of courage. But I think at the end, I think there's something healing in it. I know I found that there was. And again, you look at the tragedy of it, on the way through this, depending on how long it takes, you will lose people, you will lose friends, you will lose some of the key people that are part of the story that either put you there in the institution or helped you when you got through it or when you come out of it, And those are the hard, heavy parts for it. But again, if support, if guidance, if counseling is a phone call away, I would say to people, don't be afraid to use it, because a lot of people, again, like the courthouse setting, a lot of people would never have spoken to a counsellor. So you're going to find new challenges. You're going to find other ways of helping you through what it was. Your story is important. It helps other people tell their story. It also helps uncover part of the history and the mystery of this island. And I think that's, when you see the report, and I have it behind me, there's 10 volumes of the report. And sometimes I just open maybe book 5, book 6 of it randomly just to read something in it. And you do get inspired by the courage that people have brought to the historical institutional abuse inquiry. And you're also very, very aware of the tragedy that's been in the middle of it. So look, it will be hard. It will take courage. It will take strength. But I think there's an outcome in this, not just for people coming forward to give evidence to a prospective inquiry, but I think there's an outcome in this for society as well. Society has to accept its responsibility of the burden that it placed through its moral judgment on victims and survivors of these institutions. Sharon, thanks very much. I really appreciate the time.
Now I'd like to take a few minutes to follow up with a few questions from what we've heard today. And maybe I'll start with Brandon. And you talked about the importance of having not just an inquiry, but making this a transitional justice process and making it holistic. And I'm wondering if you could maybe elaborate a bit more on what provisions should be in place in terms of counselling for victims who are going to testify, perhaps. What should that look like, say, before they testify, after they testify, or sometime later? And then also I'm wondering, what does real participation look like after they've given their testimony? Do they have a chance later to come back and ask further questions or make comments? And what's their role once they've given their testimony?
Well, thanks very much for those questions. There's sort of 3 bits, if I hear you correctly, something about the holistic nature, the counselling issues, and what does participation look like. In terms of the holistic approach, what I'm meaning by that is that although the context I look at in terms of political conflict are different to historical institutional abuse, although, of course, they can overlap, and Northern Ireland is an example where they do overlap to some degree. In the political context, one of the values of the transitional justice approach has been to think about how you address issues in a slightly more holistic way, that it's not just about giving testimony. It might also be about justice. It could also be about memorialization. It could also be about education. And also it's importantly about institutional reform. And you might have different types of processes running parallel to an inquiry or to a truth commission, for example, rather than just one process that is taking place. And I think one of the challenges for historical institutional abuse is it has tended to be tied up in a specific inquiry, rather than saying what we're exploring here is, yes, the violations against specific individuals, but this all took place within a much wider social context. And so we need to understand that wider social context, whether that's about how the police worked or how churches operated or how communities worked at the time. So that's what I would mean by the holistic side of it. In terms of the question of counseling, again, the type of approach I would take, and from some of the global lessons around these issues, and there's a lot of developments around this in terms of the United Nations and others who are finally looking much more closely at what we might call psychosocial support to individuals who are going through these type of processes. And I use that word carefully, psychosocial, because what the research would say is it's not just about the counseling. It's not just about the psychological piece of that. How does it feel to go through this process? How does it feel to remember, having your testimony asked? All of that is important, and individuals need some support in doing that. But it is taking place within a wider social context. So at the same time as you're having that counseling, you might need legal advice, for example, or you might need welfare advice. And so you have to think of that support in a wider way than just saying, oh, before you go before this inquiry, you need to get some counseling. Actually, you might be needing a sort of wider level of support. And importantly, that happens before the process, after the process, and that there's a way that's built into the long term. What we know from the heart inquiry, for example, is that people had lots of needs, down the line. It's not, and if I think of the South African Truth and Reconciliation Commission and people I know who testified there more than 2 decades ago, they still need support today. So it's not just about saying, oh, we had a good counselor there on the day when someone was giving testimony. So I think that's how I would think about that on the counseling side. And participation is probably the same to some degree. Participation doesn't mean you turn up on the day and you give testimony or you give your statement. Actually, genuine participation is, what's happening now, hopefully, which is a consultation period to form the process that will go forward. Again, asking about the follow-up, and there might be multiple forms of follow-up. It could be about compensation. It could be about, I know that's difficult sometimes with historical institutional abuse, but some form of recognition of apology or memorialization, for example. So that participation has a life before, during, and after. And the main thing is, it just shouldn't be what I called earlier instrumentalized, which is, according to the legislation, we have to consult with victims. So we've now ticked that box. It has to feel genuine for people and that they can actually shape those processes. And so if there's they need to be asked continually, how is this going? How could this be different? What could we do next? So it's an ongoing process. It's not just something which happens when you're setting something up. And those lessons internationally are unequivocally clear.
And that really makes the difference when it comes to healing then for the survivors, to have a voice, to be asked to participate. You see that makes a difference for how they experience it.
Yeah, look, I mean, the challenge with an idea like healing is that it's highly individualized. So I wouldn't want to be general and say if you do X, you will get Y outcome because people's needs change over a period of time. So if I think of the South African Truth Commission, some of the people we worked with would have said, all I want is the truth. And then the truth would come out, and then they would say, actually, now that I hear how atrocious that was, I think I want justice. And from a psychological perspective, that's perfectly acceptable, that needs change and needs develop. So I wouldn't want to say healing is one thing at one specific time, but certainly social psychological research, for example, shows that if people feel genuinely consulted, if people feel that they're participating in processes, even when outcomes are negative, even when outcomes are not exactly what they want, they're more likely to feel a sense of satisfaction with that process. So it'll be interesting to hear what Gemma says in some levels. But from a psychological perspective, we sort of look at procedural justice, for example, differently to how a lawyer might look at it. A lawyer might look at it in terms of, were those processes objectively fair? A psychologist would say, did people perceive it to be fair? Did they feel it was fair? And those are slightly different things, because sometimes they're not about, did you follow the right procedure? It's about the nature of the chair of the inquiry, about how they make people feel when they walk in the room, the warmth that comes through, the empathy that, say, a victim support worker gives to somebody. These are things which are really hard to measure, but they make a difference to how people feel that process went.
Thank you, Brandon. And indeed, Gemma, when it comes to these inquiries, and you spoke about prosecutions, that seems very complex. And if you look at the Hart inquiry, I believe, although many were recommended, there haven't been any prosecutions, if that's correct. And I'm wondering, why that is. Why is it so hard to get prosecutions in these cases? And how does that make survivors feel if all these crimes have been uncovered and then the state doesn't prosecute the perpetrators? And then, one other question that I have is about the fairness of the process and whether or not survivors have legal assistance. Because I believe also in the Hart inquiry, the people who were, connected with the institutions had their own lawyers, but then victims felt that they weren't represented to the same extent. And so I'm wondering how we can make that more fair for this kind of a process.
Yeah, I think just on the second question, I suppose that's why I really focused on the need for core participant status. That seems to be the best practice, really, in ensuring that survivors have legal protection. Now, obviously, there's practical outworkings depending on the numbers of witnesses that are part of the process. But if you don't have those protections, you're effectively a bystander. You give witness evidence, and then your powers and your ability to influence the process are somewhat limited. Whereas if you are a core participant, you have full legal representation. Generally, that's provided for and paid for by an inquiry. They have the discretion to do that, which is obviously is a very relevant factor. And it's, whilst these aren't considered to be criminal or civil proceedings, there is an element of a trial about them. So the issue of equality of arms and fairness, why should those that have been implicated have the full legal team and advance notice 20 days in advance of disclosure, when witnesses and survivors turn up on the day and effectively don't have proper preparation time? So some protections, either like a core participant status or similar measures, really need to be embedded into the process for survivors, because they are central to the process. They need to have their voices heard. And in my view, the only way really to do that properly is through legal representation. Now, there will be arguments about costs. That's always a factor. A legal representative can represent more than one core participant. You don't have to have individual legal representation for every survivor. So it can be done creatively, but certainly looking at the Inquiries Act 2005, that provides the best protections. It gives you the power to question other core participants. Whereas if you're an ordinary witness to the inquiry, you don't have the power to direct questions on certain matters. It gives you the power to basically put questions to the chair or chairperson or panel to suggest how the inquiry should proceed. You can have opening submissions, closing submissions. So it really is, it protects your rights and really ensures that you are central to the process and you're not just a bystander. To have proper participation, in my view, you need to have legal representation and some form of ensuring that you are embedded and central to the process and not just there to provide a statement and then told, right, goodbye. I think you need to be part of the process and to have ownership of it. And to me, that seems to be the most apparent route to do that. And on the issue of prosecutions, I think that's really... Sorry, apologies, Sharon, go ahead.
Oh, I was just going to ask, would core participant status mean that survivors could then be cross-examined or treated adversarially during the process? Or how is their testimony received versus institutional testimony?
Well, those that have been implicated, so any institutions will necessarily be given core participant status. Well, that's what happened in the inquiries that we were monitoring, the police, MOD, prison service. So if you're given core participant status, you have equal rights to them. Whereas, as I understand it from the historical abuse inquiry, there wasn't the same protections and there was concerns about the participation and lack of legal representation. So you effectively have the power to then question another core participant. Whereas if you're a witness, you're limited in the breadth of the questions that you can ask. And it in fact entitles you to access to disclosure of documents that you won't necessarily be entitled to if you don't have that core participant status. So it really just gives you procedural protections that you don't necessarily have if you're a witness. You're a core party to the proceedings. Basically, you're legally protected and you have legal rights that if you're a witness, you may be at the discretion of the counsel to the inquiry or the legal team. They may provide you with material, but in my view, you need to have those rights embedded and legally protected to ensure that you have equal participation and aren't at a disadvantage. For those that have been implicated in abuse, to have advance notice and to have excess time to prepare. It's essential that those that survived that need to have equal protection, and I think that's the way to do it, through core participant status or a mechanism that replicates that. But they need to have equivalence and equality of arms. There needs to be an equal protection, and just on a matter of fairness. To me, just on a procedurally, it wouldn't be appropriate, I think, to have two tiers of representation.
And then with prosecutions,
I think that's a bigger question, and it sort of not just in this discussion, but on legacy generally. There's this issue about prosecutions and how likely they are, and obviously the first issue is, as time goes by, the likelihood becomes more reduced, and there is a possibility of prosecutions. For example, in the Robert Hamilton inquiry, one person is still subject to a prosecution, but that's one person out of a vast number of people that were interviewed. So I suppose I would argue that we need to be realistic about the likelihood of prosecutions, but the state have an obligation to investigate, and the investigative obligation states they must collate all relevant evidence, forensic, take all necessary steps to collect the evidence, potentially exhume bodies if necessary. That is an obligation that they must comply with. It isn't something that's discretionary. If they're going to comply with their convention obligations to investigate an unlawful death, investigate mistreatment, torture, investigate forced labour, they have to carry out proper investigations, and to do so, it means forensic evidence, witness statement, compelling authorities to provide the material. If they don't, they should be held accountable and they should be subject to sanctions. I feel that, for example, in the Billy Wright inquiry, I understand that the prison service was very badly criticised for destroying thousands of documents, and the police service was criticised for not complying. But I think without sanctions, words are words. I just feel that if there is to be a failure to comply with an inquiry, then action should be taken to respond to that, and to give a message to others that if you don't comply with the inquiry, that there will be implications. Prosecutions are possible, but it isn't the primary focus of a public inquiry. If you're looking through that narrow lens of a public inquiry, that isn't their primary focus. They're fact-finding. They're only about information gathering. It potentially can lead to into a prosecution, but it's not their primary focus. That would be a criminal investigation, which also could take place. There can be referral to the prosecution service, and police investigations may materialise. If that happens, Then there's an issue about whether the inquiry should still continue. Could it potentially prejudice a criminal process? So there's issues about whether one would need the inquiry would need to be halted, and that's happened in England and other inquiries. So it's a process. Really, obviously, it depends on what evidence is gathered, but at the very outset, the obligations on the authorities to gather the evidence to at least then exhaust that avenue of potential prosecutions.
Just one final question, Brandon. Do you think, like, alongside such a legalistic process, would there be a benefit to having, I think sometimes in other instances, there's a less legalistic, more truth-telling narrative sort of recounting of telling of the story, where survivors perhaps are not cross-examined, and perhaps there's more of a sense that they just need to tell their story and they'll be believed. Do you think that there's a value to having that alongside a more legalistic strand?
I think there is a value in that. I don't think the one should substitute the other, and I think where we've seen that in different contexts, that's been a problem. Where maybe it's just a truth-telling exercise, but there aren't any particular outcomes, whether that's about apologies or acknowledgements or prosecutions. So definitely for me wouldn't be an either or. But there is a potential for that complementary process, and from my understanding of the Hart inquiry, that we could maybe hear from John, but that worked relatively well, where some people had the ability to just tell their stories, had a free space to tell that, and then others who went through the formal process. I think the other challenge, of course, is you also at times need to be able to do both. So, as much as the inquiry itself might have to focus on very specific factual issues, there also needs to be a sense that people have the space to tell their own stories. So if I think of the South African Truth and Reconciliation Commission, if we look at that commission, more women told stories than men. But actually, when you looked at the stories that they told, they were telling stories about men. So they were telling stories about their sons and their husbands who were killed. They weren't actually telling their own stories. They weren't saying, what was it like to bring up a family in that context for 20 years afterwards? What was it like when the house was raided and everything was wrecked, or they were threatened? Because somehow that wasn't seen as the important part. The death of their son or their husband was seen as the important part. So you have to, even within the legal process, in my opinion, find a way that the wider part of the story can also be told, and that you don't become overly focused on specific violations at the risk of allowing the whole wider context to come out. It might be about the consequence of the violation is that, someone struggled with employment and that had, consequences in terms of poverty and their lives. Those are parts of the story that have to come out. And if we go too narrow on the legal side, you can also miss out on that. So it's about getting the balance between the two. You need both, and they could be two separate processes. But I would also argue that they need to also, you need that psychological space within the legal space as well, as difficult as that is. So I think on the issue of should the redress process be something which comes after the inquiry or the truth recovery process, or whatever process you put in place, is a really important one. And there is quite a few lessons that can come from transitional justice in relation to that. And in most truth commissions, for example, you would have a group of people who are already working on what we might call reparations, meaning it's wider than compensation. It could be about acknowledgement. It could be about memorialization. It could be about education processes for others. And in most Truth Commission processes, for example, you would have that group of people working inside the process the whole way through, so that their recommendations are not some sort of afterthought. They're actually built into the very heart of the mechanism itself. And I think that that's quite a valuable lesson. The second lesson that we've learned from transitional justice processes is not to defer the redress process to someone else or to some other body. So if you look at South Africa, there was a whole set of recommendations made about reparations, for example, a compensation scheme, a pension scheme, a range of different mechanisms. But then the commission ended, and it was up to another government body to implement those recommendations. And it took years and years and years, and they weren't really the recommendations that were made in the original report. So you might also want to be considering what is actually the role of that either internal body or another body that works very closely with the whole process, so that there's not some disconnect between the redress process and the actual inquiry process itself. And that's a big lesson that has been learned in a number of countries on truth commissions specifically, but could probably be applied to other contexts.
John, HIA victims had to wait for years after the end of their public inquiry for a redress scheme to be set up. Based on your experience, do you think the redress process should be set up in parallel to the inquiry into mother and baby institutions, given the academic research has already established that there were abuses and that there was state responsibility? Do you have any reflections on that would be useful to mother and baby institutions survivors?
The issue of redress is going to be something that will raise its head. I know it's already been part of the discussion around a future inquiry into mother and baby homes. I know when we had asked for a redress package to go in tandem or parallel with the inquiry, the civil service and Stormont's response was to do that would be to actually be predetermining the outcome of the inquiry. I mean, for me, the outcome of the inquiry was a foregone conclusion, but again, they were protecting themselves, and they weren't, I believe they weren't prepared to put money up at the start because, first of all, they've no idea what the cost is. I don't believe to this day they still understand what the cost of redress for the historical institutional abuse inquiry is going to be. But, the way society is now, if a wrong was done, something has to be done to make some effort to show that you're trying to put it right. And redress is part of that package that shows the state's willingness and the institution's willingness to put things right. So there's no reason why it shouldn't be demanded in tandem with an inquiry, rather than have to wait almost 3 years after the close of the inquiry before the legislation is agreed that redress will be delivered to victims and survivors. So, I mean, I would say put redress on the same sheet as the demand for the inquiry and ask for that to happen in parallel with the inquiry, that arrangements be made beforehand to ensure that it can happen, rather than have to wait to the end and then scramble about to figure out where it's going to come from.
And John, the HIA inquiry did not provide legal representation for victim survivors, but rather just had a set of lawyers working for the inquiry itself. Do you think that it would have been better if survivors had had their own legal representation?
When the inquiry was established, we had a meeting with Andrew Brown, who was the secretary to the inquiry. And one of the questions I asked him was about legal representation for victims and survivors coming forward. It was also an issue that I raised at Stormont. And I think that they had this view that every victim or survivor that came forward would be bringing their own lawyer into the room. And if anything, certainly after previous inquiries, I don't think the government, particularly the British government, and I don't believe Stormont, would have been keen to look at the cost of every victim and survivor bringing their own lawyer with them. In the discussion, I was told that not necessarily the view, but the position of victims and survivors coming forward would be something that would be considered by the inquiry's lawyers. In hindsight, we should have been core participants in the inquiry. And as core participants, and I would insist that if this inquiry is established, that the institutions, mothers and babies, mothers from each of these institutions, the people affected from these institutions have their own legal representative in the room if this goes to a public inquiry. Because the institutions had theirs, the Sisters of Nazareth had theirs, the Christian Brothers had theirs, social services had theirs, everybody had their own lawyer in the room when there was an issue raised that was relevant to that particular body. The only people who didn't have a lawyer were victims and survivors themselves. So, I mean, asking and demanding core participant status at the outset, and if necessary, ask for a judicial review if you don't get it. It's in the interest of justice that the evidence of victims and survivors is given fairly. If it's going to be challenged, that there's somebody there to actually take the challenge on from a legal perspective, because again, as I said, the majority of victims and survivors will never have been familiar with a courtroom setting. They will never have had to swear an oath and give evidence. And it is intimidating, and it does shut people down, and it does prevent them from giving the evidence that they want to give about the situation they ended up in and about the impact of it on their lives.
I'd like to thank you. I'd like to thank you all for speaking to us today. It's been incredibly helpful. And now I suppose the question is, what's the next step? Well, a 3-person truth recovery design panel was appointed in March 2021 and has pledged to work collaboratively with victims and survivors in the design of the most appropriate form of inquiry to recommend to the Northern Ireland Executive. So I would encourage anyone who's interested in learning more about how to participate in the inquiry design process to check out the details on how to contact the panel that are provided at the end of this video. You'll also find information there for how to contact Amnesty and Ulster University. And please do check out our other events in the series. So once more, enormous thanks to today's speakers for giving so generously of your time. It's very much appreciated. Thank you.